Again, lots going on, right, people? Hard to keep track of all of it, but I'm here to make sure that certain things don't escape your notice. One of those is a lawsuit that was filed yesterday, October 23rd. It was filed in federal court in the Southern District of New York. And the plaintiff is the Knight First Amendment Institute at Columbia University. And that lawsuit has been brought against the following: against the Office of Management and Budget, OMB, and the Department of Justice, our DOJ. Well, not really ours, right? Really more convicted felon Donald Trump's. So the reason why I want to talk about this lawsuit is it's a stellar example of how there's procedure and then a substantive kind of follow-up, like I would call a legal 1-2 punch that can work. That can work to get information and transparency to the American people. So this lawsuit is a complaint for declaratory and injunctive relief. And what that means is the Knight First Amendment Institute at Columbia University is asking for a declaration from the court as to something, and then injunctive relief, meaning a forcing of somebody or someone, and in this instance, the OMB and DOJ, to do something. It's funny because when you hear the word injunction, a lot of people think, oh, it's to block it, it's to stop it. Well, yeah, but injunctions can actually force people to have to do something as well. Or put differently or stated differently, it could be blocking OMB and DOJ from continuing to stonewall the Knight First Amendment Institute's attempts to get information from the Trump administration. So let's get into the details because it's worth it. It's a short complaint. It's only 14 pages. And again, like I said, it was filed yesterday. But let's talk about who's involved because it's important. So it is a lawsuit that is attempting to compel compliance from OMB and DOJ with FOIA, the Freedom of Information Act. You've heard FOIA used often. You've heard it, and it's essentially what it sounds like. It's this federal statute that provides a specific process with specific deadlines with which people have to comply with requests. And look, you can file objections and things can happen, but you got to be timely about it. And when you're not, you're in violation of this federal statute. And the technical statute is 5 U.S. Code Section 552. So in this instance, this is trying to get information from the Trump administration that deals with the threats that Trump made against law firms in order to punish them for not bending the knee, right? And here's a stellar example of what we were talking about. On March 6th, there was an executive order that was done from Trump addressing risks from Perkins Coie LLP. And he, as in Trump, hates Perkins Coie. It's a mission of his to take them down. But anyway, as you'll recall, because we covered it here, this executive order basically calls out Perkins Coie and just puts lies out. Because why? Well, Perkins Coie represented Hillary Clinton back in 2016. And, it was involved, this law firm was involved in the investigation into the Russian collusion that was happening with Trump concerning the 2016 election. So these executive orders, as you see here, they really were targeting DEI, diversity, equity, and inclusion practices, procedures, and policies within these big law firms. It also illegally revoked security clearances, and it materially interfered with the ability for these law firms to be able to conduct business. So we know, though, 20 major law firms received letters back earlier in the spring of 2025 from the acting chair, Andrea Lucas, of the EEOC, the Equal Employment Opportunity Commission. And they demanded the DEI data from 20 of these huge law firms. We also know by April 11th, 2025, about a month later, at least 9 of those big law firms capitulated. They bent the knee, and they entered agreements with the Trump administration to curtail their DEI programs in order to avoid basically what would end up being an illegal and unconstitutional colonoscopy of those law firms. So the Knight Institute said, you know what? We want this information. And paragraph 5 is really kind of a summation here. It says, despite the significance of these agreements with the law firms, to publicly understand the Trump administration's efforts to punish its political opponents, the agreements are not public. To fill that gap, on May 14th, plaintiff requested from defendants and others records related to agreements that were negotiated or were in the process of being negotiated between the Trump administration and the law firms, as well as the terms thereof. In addition, as it relates to these defendants, OMB and DOJ, the plaintiff requested communications between those defendants and the EEOC and between those defendants and the targeted law firms concerning those aforementioned agreements. And they attached a copy of that FOIA as an exhibit to the lawsuit. Despite these FOIA requests, the defendants have either outright denied or constructively denied the Knight Institute's request by either failing to process the FOIA request and or to release records that would be responsive within the timelines that are required by FOIA. So let's dig a little bit deeper, shall we? We talked about the fact that the acting EEOC Chair Lucas, sent these letters to 20 major law firms. And these letters sought information about the law firms' DEI programs because the administration wanted to assess whether those DEI initiatives, quote, disadvantaged white or male employees, applicants, or trainees. And then, for example, though, you had big law firms like Skadden Arps. Before they even became actual parts of executive orders, right, they ended up bending the knee and capitulating, paying, all this money, committing $100 million to pro bono work to support the Trump administration's legal causes and saying that it would pursue merit-based hiring, promotion, and retention, et cetera. But nobody has actually seen that agreement by and between Skadden Arps, for example, and the Trump administration. Paragraph 18, at least 9 law firms that got these EEOC letters purportedly struck deals with the Trump administration, committing to, among other things, quote, no longer categorize any lawful employment or practices, including those addressing equal employment opportunity, accessibility, or reasonable accommodation for religion, disability, or pregnancy as DEI, and to not engage in unlawful discrimination, including any policies, programs, and practices previously labeled, characterized, or framed as a diversity or DEI program. Other law firms took steps to revise or to scrap their DEI initiatives that the Trump administration might deem illegal. For example, Sidley Austin changed the title of its, quote, Chief Diversity Equity Officer to, quote, Chief Inclusion Officer. Greenberg Traurig took down references on its website to the firm's affinity groups, and DLA Piper disbanded its minority organizations and affinity groups. So on May 14th, the Knight Institute said, we're submitting a FOIA request to you because we want to get 2 categories of records. We want to know about these negotiated agreements between the Trump administration and what would be called a, quote, targeted firm. And we want to know what the terms of these agreements were. And those were the requested documents. In addition, the FOIAs said this: we not only want the copies of those agreements, right? We want records that were created that deal with any of the terms of those agreements, including, quote, all communications between any targeted firm and OMB, the EEOC, and or DOJ, and all communications between or among the White House, OMB, the EEOC, and or the DOJ concerning those agreements with those targeted law firms. And in the end, OMB and DOJ haven't turned over shit. To add insult to injury, here's what's crazy. One of the responses from OIP, which is the Office of Information Policy, for DOJ, they've pretty much said, you know what, your request, we need to go beyond the 20 days that we have to be able to respond. And the OIP never gave an estimated date by which they're going to produce it. So basically, in the end, it's just left open-ended, right? And so the Knight Institute said, screw that, you violated the law. And so it's brought a 1-count lawsuit that's a violation of FOIA. Failure to respond to plaintiff's request and to make agency records available. And that's against both OMB and DOJ. And it's very clear here. It's saying you didn't give me the you did not give me the records that were responsive within 20 business days of receipt of my FOIA request. In addition, OIP stating indefinitely there's a delay up to 2 years without a final determination, and where OIP has refused to engage with the Knight Institute regarding an alternative timeframe of processing is tantamount to a constructive denial. I mean, can you imagine? dealing with a federal statute, you're like, yeah, I'll get back to you. I'll get back to you. And you just punt it the whole damn time. The prayer for relief, which begins on page 13, says, Knight Institute wants the court to order these defendants to conduct a thorough search for your records, declare that the defendants have violated FOIA by improperly withholding those documents, to enjoin OMB and DOJ from withholding those requested documents, meaning let's stop them from continue to withhold it, and let's order them to produce those requested documents by a date certain, right? To enjoin the defendants from charging the Knight Institute for searching, reviewing, and to duplicate or make copies of those records. And under the statute, the Knight Institute can get its fees and costs incurred for having to bring this lawsuit. And as you've all learned here at the Katie Phang News Channel, to grant such other and further relief as the court may deem just and proper. We know that is a catch-all that is incredibly helpful in litigation. So the FOIA request was served on OMB DOJ. They had 20 business days. They failed to comply. They've been making up bullshit excuses. And now the Knight Institute says, peace out, people. We're going to go to court for it. And the reason why I wanted to talk about this lawsuit is, when was the last time that this issue concerning the law firms crossed your mind? I bet you it's been a long ass time, right? Because there's just been so much chaos and just so much bullshit that has been put up and thrown up by this administration. It's their strategy, right? It's the Steve Bannon flood the zone with bullshit strategy. And it works because we forget. And that's okay, people, because I'm here to help us remember. But we all forget. I'm a part of it too, because, we're just treading water these days. But when you have this type of process lawsuit, where you have this type of lawsuit that says, these laws exist, you don't comply. I don't care if you think it's a technical noncompliance. The law requires you to do this. Why? Because it's the information, the underlying substantive information that's going to be it. Don't you want to know? Was it straight up extortion like we know it is? Was it insinuations of rewards of, let me hook your ass up later on with lucrative deals or contracts with the federal government? I mean, don't you want to know? I do. So I laud the Knight Institute at Columbia University for filing this lawsuit, for going against the administration and saying, give me the information I demand that I am legally entitled to. Because the public, you, me, everyone, we deserve to know what the hell's going on. Does this remind you of something else? I don't know, the Epstein files? Folks, sometimes the cover-up can be worse than the crime. In the Epstein file situation, absolutely not. In this instance, it suggests there's something very nefarious going on, does it not? It's like a consciousness of guilt example. You know there's something incriminating, and that's why you won't turn it over. Because if the communications and the agreements were legit and kosher and not a problem, and you would think so if these are major freaking law firms, big global law firms that are doing these agreements with the Trump administration, you'd think they'd be not only pretty well damn drafted, but that they would be airtight against measures of scrutiny that are being brought by just little old me and little old you. But the silence is deafening, and the non-compliance is even worse. So let's see what happens in this lawsuit. And let's see what type of orders are obeyed by the Trump administration. Be mad, be outraged, demand accountability. I'm off to rattle some more cages. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.